Explain this. To file a civil complaint, you need a reasonable basis in fact and law. Allegations can be made on information and belief. Now, a motion to dismiss tests the legal sufficiency of the complaint. Assuming everything in the complaint is true, does it state a claim upon which relief can be granted? So for a motion to be dismissed, everything is assumed to be true and all reasonable inferences are granted to the plaintiff. And if the judge still doesn't think that there can possibly be a case, even down the road after discovery, he or she will dismiss the case. One of the things that troubles me greatly is a number of the cases that the Trump campaign have brought have been dismissed, and in my view should not have been dismissed. And what the media do is, rather than explain the nature of the case and what it is that the Trump campaign is alleging, they just say, oh, they lost another case, was dismissed. Why? Now, let's talk about discovery. Expedited discovery. So you bring a case, you have to pass the motion to dismiss standard, which typically is fairly easy. You don't need all this evidence for a court to accept the case, as I explained. And then you can seek expedited discovery to gather all the evidence that you think is out there. An expedited discovery can be granted by a court, and it often is, when injunctive relief is sought by temporary restraining order and or preliminary injunction. Depending upon the need for prompt resolution, and we have one now given the clock, that discovery can be ordered immediately. The judge can do it right at the desk, order it, and courts have the power to speed discovery along and very fast. Now, let's talk about, as an example, this Dominion voting system. Unexplained, significant deviations from expected results. For instance, mathematical inconsistencies supported by experts. In other words, expert testimony given in affidavits should be more than sufficient to establish a reasonable basis to file a complaint and justify expedited, fast discovery. So it's all wrong when you hear legal analysts and hosts say, where's all the evidence? Where's all the evidence? This is a civil suit. So you have the bar you need to pass, so your case isn't dismissed. Then you conduct discovery. Written discovery, document demands, depositions, and so forth on an expedited level. That's how it's supposed to work. So it is frustrating to me to listen and watch people who have no experience in civil litigation, know nothing about civil litigation, or former federal prosecutors and professors who should know better, saying the same thing, or political operatives with whiteboards and without whiteboards. I'm afraid there's no evidence. We don't have the evidence, there's no evidence. So if judges prevent the Trump campaign from going forward in, for example, involving the Dominion voting system, they're never going to gather the quote-unquote evidence that's necessary in a trial, in a court proceeding, or where you're seeking some kind of remedy or relief. Because you don't go to court with boxes and boxes full of evidence. Sometimes you can, but you're not required to. And so all this talk from Republican senators who have no idea what they're talking about, Mitt Romney, Ben Sass, who was just elected, so he's not all worked up about anything, Adam Kinzinger, it's over already, and so forth. Maybe it is, maybe it isn't. But why won't they embrace our legal system? Why won't they embrace our constitutional system? Why don't they encourage the courts to go ahead efficiently to act on these cases so we can get to the bottom of it? And there's reasons to be concerned, ladies and gentlemen. There's different kinds of cases the Trump campaign is bringing. Number one, of the sort I just said, they want to test this machine system, either now or in the very near future, with a filing. But they're getting their experts lined up and they're getting their affidavits lined up. How do I know? Because unlike most, I've asked them. Number two, you have cases of actual fraud. The Trump campaign in various cities and states have collected hundreds and hundreds of signed affidavits under penalty of perjury from election workers, from state officials, from civilians, hundreds and hundreds. That's hundreds and hundreds more than they ever had in the Russia collusion hoax. So these are serious cases that they're bringing. I can't help it if judges are getting nervous and they don't want to pursue it, or they're Obama appointees or whatever they are, or left-wing rogue justices, as you have the majority on the Supreme Court of Pennsylvania, just like you had in Florida in 2000 on the Supreme Court of Florida. What other kinds of cases? Constitutional cases are being brought, very serious cases, under Article 2, Section 1, Clause 2, with the United States Supreme Court. Associate Justice Sam Alito has already reached down into Pennsylvania twice and ordered them to protect certain ballots in case the court rules that what the Pennsylvania Supreme Court did may be unconstitutional. What am I talking about? Article 2, Section 1, Clause 2 of the United States Constitution. Each state shall appoint in such manner as the legislature. They specifically say the legislature. You won't find that in many places in the Constitution where they're specific about that. The legislature thereof may direct a number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress. In other words, the state legislature makes election laws. And I can tell you from my own research way, way back, there's no way the framers of the Constitution or the ratification conventions would have approved this Constitution if the legislatures themselves weren't in charge of the voting systems, weren't setting the laws. You need to understand there was no federal government. They created this federal government, and these states had to buy into it. In one of the areas where the states said, we'll only buy into it if you protect our authority and underscore our authority to determine what the election laws are. So when you have the Pennsylvania Supreme Court, or you have a consent decree in Georgia, or you have a federal judge in Michigan, or things of that sort going on, interfering with decisions by the state legislatures, that is unconstitutional, and that should be raised. And how many ballots does that affect? Nobody knows. It could be hundreds and hundreds of thousands. Now, as was pointed out by ABC News some time ago, let's talk about these legal changes that have come. You want to know why there's litigation going on? You want to know why this is taking so long? Because the Democrats and their surrogates in the Biden campaign brought over 200 to 300 lawsuits in the lead up to the election to change the voting systems in each state. And the Trump campaign is trying to address them now, confront them, and deal with them, because all of these cases that involve the Democrats were intended to make fraud easier, if not institutionalize it. And they write in ABC News, thanks to legal challenges from voting rights advocates, meaning left-wing Democrats and their party, some states that typically require ballots to be received by polls closing time will now accept ballots postmarked by Election Day for the 2020 election. The Pennsylvania Supreme Court said, we don't even care if there's a postmark. We don't care if there's a signature. We don't care if the signatures don't match. That was a case brought really by the Democrat governor who couldn't get these things from the Republican legislature. So they went into court and got it from the Democrats on the Supreme Court. In the three blue wall states the president won in 2016, they wrote, Michigan, Pennsylvania, Wisconsin, judges have recently issued rulings that extend the deadline for mail ballots to be received. Judges. The text of the Constitution says that's unconstitutional. Judges don't get to make that decision, whether they're state judges or federal judges. That's in Michigan, Pennsylvania, Wisconsin. In Michigan, a court of claims judge, the lowest judge there is in the state, ordered clerks to accept ballots that are postmarked by November 2 and received within 14 days of the election, the deadline for results to be certified. These ballots have to be counted as provisional ballots. Legislature didn't pass that. The Republicans didn't agree to that. In Wisconsin, a U.S. federal district judge ruled that ballots postmarked by November 3rd can be counted as long as they're received by November 9th. The legislature didn't do that in Wisconsin. And in Pennsylvania, these are all Republican legislatures that are being overruled by courts, by these voting advocates, Democrats who are bringing these cases. And in Pennsylvania, not only will mailed ballots that are postmarked on or before 8 p.m. on Election Day and received by 5 p.m. the Friday after it be counted, due to a ruling from the state Supreme Court, any ballots that arrive within that time frame without a postmark or with an unreadable postmark will be presumed to have been sent before the cutoff point unless evidence indicates otherwise. That is a violation of the federal Constitution. State law did not provide for that. In Minnesota, ballots postmarked by Election Day and received within a week after the election will be counted. Both Massachusetts and Kentucky are allowing postmarked ballots received by November 6th to be counted. In New Jersey, it goes on and on and on. These changes have been taking place. Notice this. I don't know of a single newsroom that has put a chart on the monitor to show you all the changes that occurred in the last year or so, even in the last 90 days, in these states by court order or by decisions of secretaries of states or boards of elections to get around Republican legislatures. This is a highly abusive and controversial election across the country. In Georgia, a federal judge ruled that ballots postmarked by election day will count if election officials get them by the third day after the election. But the Secretary of State, the Republican National Committee, Georgia Republican Party are challenging this order. But you have courts that are just stepping in and changing the election laws. And this is really quite shocking. Trump campaign lost its lawsuit in Nevada, seeking to stop the state from mailing out ballots, among other pursuits. Nevada changed its mail-in procedures, that they're mailing it to the election rolls 60 days before the election. 60 days. Then they put in ballot harvesting. They did a very controversial way of checking signatures that, of course, excluded any Republican observer. And you can go on in New Jersey and these other states. So these are very serious matters. So when you have politicians who are just out there saying, like Romney has no idea what I'm talking about. He hasn't looked at a single thing. Neither is Sass, Mr. Constitution. He's not Mr. Constitution. Now, what should happen in these states? What should have happened and what should happen is that these Republican state legislatures in Pennsylvania, in Michigan, and these other states, Georgia and so forth, they should have issued a resolution early on stating that we, under the federal Constitution, have an oath and have a duty to ensure that Article 2 is upheld, that we make the election laws, not anybody else, period. And that the election laws that were in place but changed by federal and state courts or by fiat by a Secretary of State or election board are null and void. And all counts should be based on the election laws that we put in place that were unconstitutionally altered. Any votes beyond that are illegal and unconstitutional, and if you're going to cry about disenfranchisement, blame the Democrats, the courts, and the people who did that. That's how you have a constitutional vote. That's why that matters. And I also fault the United States Chief on the United States Supreme Court, John Roberts, the Chief Justice. He could have killed this right away, several weeks ago, when he should have voted with the other originalists, and so should have Kavanaugh, instead of letting Pennsylvania get away with what it did. What they should have ruled is, for Pennsylvania and for every other state, the Constitution is the Constitution. Article 2 leaves it to the legislature. Any changes done by any court, local, state, or federal, done by any public official, governor, secretary of state, or members of any boards of election, are per se unconstitutional, and all counts will be based on the federal Constitution, what the state legislatures have passed. If they had done this, almost none of this would be going on. Almost none of this. So those people that say, Biden won, let's get over it, let's move along. If you believe in the rule of law, if you believe in the Constitution, if you believe in the nature of civil litigation, that there needs to be some discovery with the Dominion voting system and other activities that took place, where we literally have hundreds and hundreds of affidavits of fraud. If you believe in that system, then it shouldn't be cut short. Otherwise, the entire integrity of your franchise is called into question. And it'll happen in 2022 and 2024. This isn't the Republicans won't let Biden be seated. This is the Democrats have created chaos and anarchy. Judges have created chaos and anarchy. And if we don't fix it now, we'll never fix it. And Joe Biden better understand that there cannot be unity and there will only be resistance. If he doesn't join in the call to uphold the Constitution and the rule of law and to let these civil procedures progress. Notice he hasn't said it once. Not once. I'll be right back. Now, in addition, troubling to me is the strategy of the Democrats. These were Democrats who brought these lawsuits basically to soften up the playing field. Almost like a military operation. They brought in